Morning. This is 24 CR 0079. Mr. Daly, you're both 1989. Last four digits, social security number 6037. We're here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, we're in the process of getting all the records. We're contacting the providers again. A lot of them in the mail, so I think we'll have them by negotiation day.
What is the negotiation day?
Like June 13th at 9. It's all right, Mr. President.
Yes.
June 13th at 9, and the next court date's June 18th. Okay, thank you very much. Colton and Randolph. Commonwealth of Kentucky versus Colton and Randolph, 24 CR 0087. Are you Colton and Randolph?
Yes, Sean.
Good morning. Were you born in 2006? Last four digits, social security number 4446.
Yes.
What does the Commonwealth have to say?
Your Honor, on that case, there's charges in the name from Pulaski County. Since there was no agreement on transferring the case, I'm presenting those Pulaski County charges to the Clinton County Grand Jury today, and then I'm going to move to consolidate all of them. We have to have a hearing again, so.
No, tell me what, there was an agreement on what?
The transfer of the case from Pulaski County.
Who didn't agree to that?
Well, I don't think the defense did, so. I want to consolidate it that way, so.
What's the deal?
I think Mr. Randolph would like the grand jury to hear the case.
I can do it either way. It doesn't matter to me.
Well, he can be tried in both places.
He could be, but I've talked to the Commonwealth Attorney David Dalton up there. And if we have a trial in both places, there's going to be a 404B here in Clinton County about
Absolutely.
So we're trying to economize everything and get everything down here in Clinton Circuit Court. But
There's no
Dalton agreed
reason
it
to
should
come
be
back.
down
This
here.
gentleman wants to subject himself to the possibility of being sentenced two different places. Let him do it.
Yeah.
Okay,
We'll see
we're
what
going to
happens.
put this back on here.
Put it back on for the June motion day.
June 18th. Joshua Shaw, looks like it's a Cumberland County case, is that correct?
Yeah.
Commonwealth versus Joshua Shaw, 25 CR 0004. It is a Cumberland County case, Mr. Stockton.
It is.
Cumberland Circuit Court's now in session by agreement in Clinton County. You are Joshua Shaw.
Yes, sir.
Good morning. You were born in 1993.
Yeah.
Last four digits, social security number 3558.
Yes, sir.
Yeah, I understand that you wish to hear a plea today. Is that correct?
Yes, sir.
Is this a felony plea that you got here?
Yes.
Okay. A motion's been tendered. It says you wish to enter a plea today. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Your Honor, he hasn't signed this yet. Can I speak with him and go over this?
Well, it'd be good if you read it before you entered it. I always like people to read things before they enter it.
I agree, Your Honor. Okay, thank you.
You got all these other cases, so I'm not gonna stop now.
Yeah.
Why haven't you met with them previously?
This
This is not district court. I do not operate like that, okay? I'm not, you call these people up here to enter a plea. You need to have gone over it with them, give them plenty of time to consider it. I don't really like taking his plea with him looking at it for 5 minutes. What does the Commonwealth have to say?
Well, we negotiated over time, so we're well aware of the terms. It'd be 7 years to serve.
Okay. We just have him back there. He's, but I've got all these other people waiting here that you got. So, Larry Thompson, Commonwealth versus Larry Thompson. Commonwealth versus Larry Thompson, 25 CR 0026. Are you Larry Thompson?
Yes, sir.
Good morning. Were you born in 1979?
Yes, sir.
Last four digits, social security number 2745.
Yes, sir.
What does the Commonwealth have to say in this?
And Mr. Thompson, what's the trial date, Your Honor?
Okay, what's the charge?
Theft.
How complicated, is it a 1 day trial?
It's 1 day trial.
You have any out of town witnesses, either one of you?
I'm worried.
Your Honor.
How about are Wednesdays okay days here? How about June the 4th?
That's fine with me.
What time is it? There are not gonna be any pleas now. You understand that? You're gonna be tried that day. You understand?
Yeah.
Okay, no problem. Tyler Eminent, Commonwealth versus Tyler Eminent.
What was that?
June. Second.
Mr. Eminent, you raise your right hand, please. You are Tyler Eminent. You are Tyler Eminent, is that right? You born in 1991, last four digits social security number 7104. You say that you cannot afford an attorney, is that right?
Right.
Okay, you solemnly swear the testimony about to give us the truth, whole truth, nothing but the truth.
Yes.
You say you don't have any job. You put your hand down. You have any job? You have no job?
No, you're
Why?
right.
Why don't you have a job?
I've just now got released out of the jail. I've turned in applications. I'm looking
How long you
for,
been in jail?
I was in there, from, March 6th to the 22nd of, this past month.
Did you have a job before
No.
that? How long has it been since you had a job?
I think of, June of last year.
Okay, what's been the problem?
I was just going through a bad divorce and just following them out, and just found myself in a mess, just trying to get right.
Okay, well, I'll appoint you a public defender, but, I'm gonna hold in reserve whether or not I'll assess you later. Feel it's not part of the same. You hear the purpose of arraignment, you have a right to remain silent. Anything you say could be used against you. You're having a lawyer. If you have any questions, step back. The grand jury of Clinton County has returned an indictment charging you with possession of controlled substance in first degree methamphetamine and possession of drug paraphernalia. Do you understand those charges? Understand what the charges are?
Yes.
Counselor, you acknowledge the identity of your client, proceed indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, sir.
I'm signing a reciprocal discovery order, Mr. Eminent, Commonwealth, that will provide your attorney certain evidence to help you prepare for your case. You have a negotiation day on June 13th at 9 a.m. here, and your next court date is June 18th. Both of them are conditions of your bond. Okay.
And Your Honor, June 18th, that's on a Wednesday, is that correct?
Yes, I think you should put some order in
June 18th.
Thank you.
Sorry for the 13th and 18th. Yes. Thank you.
James Armstrong. Palmo versus James Armstrong, 24 CR 0013, 24 CR 0035, both for free trials. You are James Armstrong.
Yes, sir.
You born in 1963.
Yes.
Last four digits of your social security number 8043. We'll get the pre-trial conference. What's the Commonwealth have to say?
Have a felony plea on.
Okay. Mr. Armstrong, I've just been informed that your attorney's filed a motion, says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Is this plea freely and voluntarily given? Good. Are you the same person named in this indictment?
Sir.
Is your judgment impaired in any way today? Is your judgment impaired in any way today?
No, sir.
Have you discussed these matters with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? You believe you're fully informed about your case? You understand that you do not have to enter a guilty plea. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply a range of sense provided law. I don't have to accept your recommendation. Prior to accepting your recommendation, I will await a pre-sentence investigation report done by probation and parole. In the event, after reviewing that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. Do you understand that? Mr. Stockton, when you come forward, sir, you step to your left, step to your left, step on over to your left next to your attorney. Okay.
Your Honor, Mr. Armstrong will plead guilty to the amended charge of assault under extreme emotional disturbance. He'll receive a sentence of 5 years probated for 5 years supervised. He'll receive credit for time served 3 months and 10 days. He'll have no contact with the victim by any means. He'll pay restitution amount of $670 within final sentencing to be dispersed back to the Crime Victims Compensation Fund, and all other evidence in this case will be destroyed.
This is okay with the victim?
This is a case that was mediated with Judge Patton. The victim was there. And basically, the reason it's mitigated is because Mr. Armstrong's current health conditions.
So it's fine with the victim.
Fine with the victim.
Is that what you've agreed to, sir?
Yes, sir.
Are you pleading guilty because you committed the act charged in the indictment as amended? Are you pleading guilty because
Yes,
you
sir.
committed the act? Are you doing so under your own free will?
Yes, sir.
Knowing your constitutional rights have explained to you, is it still your desire to proceed with a guilty plea and allow the court to fix your punishment?
Yes.
You understand that after entering this plea, you will be a convicted felon. And any future convictions could be enhanced in the range of penalty of a persistent felony offender law. Do you understand that?
Yes, sir.
Is that your signature there on the document? I'll accept your plea. You need to meet with the probation and parole officer there. And be back here for sentencing on June the 18th. Continue released on the same conditions of.
Thank you, Carl.
Yeah.
Mr. Patton.
John Baumert. Commonwealth versus John Baumert, 25 CR 002023. Are you Mr. Baumert?
Yes, sir.
You born in 1967?
Yes, sir.
Last 4 digits, social security number 5834.
Yes, sir.
It was a Commonwealth have seen.
Your Honor, I learned some new evidence and more witness statements and more things for next month, and we have another month and another pre-trial.
Okay, you'll have a negotiation day. You'll come back on a negotiation day on June the 13th, and the next court date is June the 18th. Both of them are conditions of your bond, okay?
Yes, sir. Thank you.
Rick Carver. Commonwealth versus Brett Carver, 25 CR 0017. You are Brett Carver.
Yes, sir.
You're born in 1976. Last 4 digits, social security number 5893.
Yes, sir.
Represented by counsel. What does the Commonwealth have to say in this?
Well, we furnished his counsel records from his other case that he was indicted on. I thought there was going to be a motion filed.
having not reviewed that other discovery, that motion's not ready yet, so I'll just give more time.
So I guess we need to have another pre-trial, give council time to file his motion, and we may have to have evidentiary hearing. I don't know if I'll see the motion.
What was it, gonna be it was a 404B?
No, I think he's gonna file a motion based on double jeopardy, if I'm correct. And I may need to have some testimony put on from the state police, so once I see the motion.
Yeah, it is kind of interesting
It is, it's not.
concept, where you had a person with an ongoing acts of theft that he pled guilty to.
Yeah, I guess,
And then you find some other acts of theft. Is every time you commit an act of theft, is it a separate offense?
that's gonna be the question.
Inquiring minds want to know.
Maybe it is true in first impression.
Yeah, I'm always looking good for that. I'm not always right, but I'm never in doubt. So, okay, well, when you want him back here on the 18th,
Yes.
no reason to do a negotiation now.
No.
The 18th and having motions filed by then, and since there's probably not gonna be any good to do negotiating, we'll set a jury trial, okay?
Well, it may be a really good motion. I mean, you may want to negotiate.
Yeah, I'll say, we'll hear the motion, but you need to have your calendar with you too, so.
That's fair.
If you get to me early enough to read, it'd be good.
Sure.
Okay, thank you. 18. Christopher Connor. Cromwell versus Christopher Connor. Are you Christopher Connor?
Yes, sir.
Good morning, Norton. This is 25 CR 006. I'm going to tell you versus Christopher Connor. Were you born in 1982?
Yes, sir.
Last four digits, social security number 5347.
Yes, sir.
Now, who is your attorney?
I'm on by Zoom, Judge.
Yeah. Okay, what does the Commonwealth have to say about this?
My understanding is, Your Honor, we have a misdemeanor plea on Mr. Connor and a felony plea on Ms. Connor.
That's correct, Judge. And Mr. Stockton and I have been going back and forth up through this morning on this. So I've communicated that to Mr. Connor, and as far as I know, we have a resolution.
Let's do Ms. Connor's thing first. She can stand over here. Okay, Ms. Connor. Virginia Connor, Commonwealth versus Virginia Connor. 25 CR 005. Are you Virginia Connor? Are you Virginia Connor? You born in 1983? Last four digits, social security number 3171.
Yes.
You're here. I've been informed that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
No.
Are you the same person named in indictment number 25 CR 005?
Yes.
Is your judgment impaired today in any way?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Her advice, right? Have you reviewed the evidence Commonwealth has against you, believe you fully informed about the case? You understand that you do not have to enter a guilty plea, you have certain rights under the Kentucky United States Constitution. Your right not to testify against yourself, no one can make you say anything, your right to speak trial, but jury, right to be represented by counsel at jury trial, right to confront and cross-examine all witnesses called testify against you, your right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, your right to prior comment, proving on a reasonable doubt that you guilty charge. You understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, or I may give any range of sense provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I'll wait to produce an investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation, Mr. Stockton?
Ms. Connor will plead guilty to theft by unlawful taking over $10,000, receive a sentence of 10 years, serve 180 days in jail. If the balance probated for 5 years supervised, she'll owe restitution in the amount of $6,200. First payment of $250 will begin 30 days after being released from incarceration. It will be jointly and severally with the co-defendant Chris Connor. Restitution subject to clerk's fee. Probation is to be supervised. Defendant shall receive credit for any time served and have no contact with the victims to maintain gainful employment after she released.
Is that your understanding of the plea?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment? Okay. You're doing so your own free will. Knowing your constitutional rights, as I've explained to you, is still your desire to give up those rights and enter a plea of guilty to the charges and allow the court to fix your punishment under range permitted by law. You understand that after entering a guilty plea, you'll be a convicted felon, and any future convictions could enhance or range your penalty under a persistent felony offender law. Do you understand that? Okay, you have a document there in front of you. Is that your signature on there?
I need to sign it.
I'll accept the agreement, order a pre-sentence investigation report to be done by probation and parole. And we'll schedule your sentencing on, June the 18th.
Thank you, Judge.
You're in custody of the jail. Christopher Connor, your CR 008. You born in 1982, the last four digits.
Sorry, I was
The last four digits, social security number 5347. I understand that you wish to enter a misdemeanor guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes,
Are you the same person named in the indictment?
yes.
Is your judgment impaired today in any way?
No, sir.
And discuss these charges with your attorney. Are you satisfied with her advice? Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about the case. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have the right to speak, trial by jury, right to be represented by counsel at your jury trial. The right to confronting, prosecuting all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by
Yes,
entering a guilty plea, you give up those rights.
yes.
Now, this is misdemeanor plea, so I don't have to have a pre-sentence investigation for it. So listen very carefully to what the Commonwealth has to say.
Yes, sir.
Move to your left a little bit, sir.
Yeah, Mr. Connor would plead guilty to receiving stolen property less than $1,000. He have a 12-month sentence probated for 2 years. He'll pay restitution jointly and severally with Ms. Connor in the amount of $6,200. He'll pay $100 a month, beginning 30 days from the entry of this plea, subject to the clerk's fee. Probation will be unsupervised, and probation continue until all restitution is paid in full.
And what's court cost?
$155.
$155. You need some time to pay that?
Yeah.
Okay, well, let's you pay an additional restitution. You can pay that at $30 a month. So there's a lot you get. Is this awful what you agreed to?
Yes.
Are you pleading guilty because you did commit the acts charged and you amended in that?
Yeah.
Are you doing so of your own free will?
Yes.
Knowing your constitutional rights, I explained to us that still you desire to give up those rights, enter guilty and allow the court to fix your punishment according to law.
Yep.
You understand, is that your signature? You got
I'm not
it
saying
signed?
sign, I just got it.
Okay, we'll go ahead and enter the judgment on the thing. Since it's a misdemeanor, I'll accept the plea agreement. You'll need to meet with the probation and parole officer.
It's just misdemeanor.
Pardon?
What?
Misdemeanor.
He's gonna be on probation though, isn't he?
Oh, is
No,
So you didn't put him on probation?
he's on probation, sitting on the.
Well, now, I'd like for you to get the information on it. The
Okay.
fact that it's unsupervised doesn't mean he's not on probation.
I got you.
Connie Cooper, Connie Cooper. Ms. Crawford, I think that finishes your business. You have another case here?
That's all I have, Judge, if I can be excused. Thank you.
Connie Cooper is an expungement. Does Commonwealth have any concern about that?
No,
Okay. We need a misdemeanor judgment.
I didn't talk about it because.
Okay, we'll hear it today for you. Matthew Crutchfield. Matthew Crutchfield. For arraignment, what do we know about Matthew Crutchfield?
I don't know what's his bond condition. It's not here. He might have bond.
He did make one. It was a $50,000 jury bond.
What's he charged with?
Thank you. Yeah, it's possession, Your Honor.
He's been served. Obviously, made a bond. He should have been sworn for failure to. Isaiah Garman. Commonwealth versus Isaiah Garman, 24 CR 0080. Are you Isaiah Garman? Are you Isaiah Garman? Good morning. You were born in 2001.
Yes, sir.
Last four digits, social security 1566.
Yes, sir.
You today here on 24 CR 0080 for a pre-trial conference. What's the conduct?
Your Honor, we entered into an agreement that he's to pay the restitution in this case, and if he pays it, I'll dismiss the case. And if he's not paid the next month, I'll be asking for a trial.
Yes, sir.
What's the restitution
It's
for?
right at $5,200.
What's it about?
It's $1,800 less than $7,000.
What's it about? What,
It's the dispute between him where he was paid for the work and he got disappeared for the victim.
okay, yeah, are we clear? Yes, sir, about this? And so, I mean, by this date next month, means exactly that. It'll be, we'll be back here in court on June the 18th.
I'll have it.
We'll be ready for a speedy trial. We'll give you a speedy trial. So guarantee that constitutional right for Mr. Poindexter.
That's right, Your Honor. Thank you. Thank you.
Gary, Mr. Is Gary this way you say your name?
Yes, sir.
Okay. Commonwealth versus Derek Gary, 25 CR 0015. Good morning, sir.
Good morning.
Were you born in 1983?
Yes, sir.
Last four digits, social security number 3165.
Yes, sir.
And we're here for pre-trial conference, closing comment there, sir.
Well, he's representing Mr. Gary. Last time he said that we'll have private counsel here. And I got a phone call from Mr. Hoover, so I don't know who represents him.
Yes, sir. Mr. Hoover advised me, yes, said if you could put it out for 30 days, instead of some of the money against to hire him. And I hired him, I didn't hire him. He didn't take the money. He wants to take a look at it, because I just pushed it all in at once.
Well, I would suggest this, whoever's representing, be here June 13th, and it could be Mr. Rutherford, along with somebody.
June 18th.
Well, I mean, the negotiation. He ain't be here tomorrow.
June the 13th, have to be there with a lawyer.
Yes, yes.
Okay, now here's what I'm gonna do. If you're not there with a lawyer on June the 13th, I'm gonna hold you in contempt. Because this is the second time you've been here saying that you're gonna have a lawyer.
Understand?
Okay, and the next court date's the 18th, so you'll be at 9 a.m. with your lawyer. And on the 18th, you're also, okay?
Thank
Yeah. Brittany Gerke. Commonwealth versus Brittany Gerke, 25 CR 0018. Are you Brittany Gerke?
Yes, sir.
You born in 1983. Last four digits, social security number 3419. Here is the purpose.
I
Is
was
that
born in
correct?
86.
Born in what year?
86.
86. We used to game 3 years. You haven't been here 5 minutes. You're here for the purpose of arraignment. You have a right to remain silent. You're here with your attorney. Do you acknowledge your name, counsel?
Yes, Yasmin King.
And you have a right to remain silent. If you don't understand anything that's going on, step away from the podium and ask your counsel. The grand jury of Clinton County is returning an indictment charged with unlawful taking of disposition or complicity of theft, unlawful taking of disposition, and unlawful access to computer first degree or complicity have unlawful access. And the indictment form is rather unusual one. It's okay. You acknowledge the identity of your client, receipt of the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
And I'm signing a reciprocal discovery order that requires the Commonwealth to provide you with the information to help your attorney prepare for your case. You'll be here on the negotiation date on June 13th and your next pretrial on June 18th. I'll let you remain free on the same bond, okay?
Thank you, Judge.
Very much, yes. Commonwealth versus Bobby Hicks. Commonwealth versus Bobby Hicks. Yeah. Doing a arrest warrant without bond. He was one that was in a hospital, right? Here-
Bobby Hicks is here, yes.
Mr. Hicks is here. Commonwealth versus Bobby Hicks, 23 CR 00017. Are you Bobby Hicks?
Your Honor, he's a little hard of hearing.
We can take care of that. Mr. Hicks, can you hear me now? Oh, I'll speak up a little bit. Can you hear me now?
Yes.
Okay, good deal. You're here for a probation revocation hearing. You were born in 1966.
Yes, sir.
Last 4 digits of social security number 7813. Is that right, Mr. Stockton? If you want to move over here and get in the picture. Go ahead.
Let me get my notes. Mr. Hicks has 5 years sentence on wanton
I need to
endangerment.
get over closer to the microphone.
Mr. Hicks has a 5-year sentence on wanton endangerment. He was positive for meth on June the 12th of 24, November the 6th of 24, and January the 24th of 25. He's not eligible. We was going to put him in drug court. He's not eligible because of the prior sex offense. So, Mr. Payne was going to send him to long-term treatment and he refused to go. So that's the facts.
Good.
We'll stipulate, we just ask where he has health conditions that the court considers IOP for him. And he said he'd be willing to do an IOP program with the Donta.
He was in it, he failed out last.
Already done that.
So would you be willing to do rehab? Rehab?
I'll be willing to do IOP and counseling.
Doing IOP. Would you?
He's already done, tell me he's already done IOP and flunked out of it, they said.
Where at?
Do you know, we have a
Okay,
rehab?
well, I'll revoke him and some custody.
I don't care for the matter.
Okay.
Well, I'll take a look at it, but it's not, let's make a deal. You know. Joshua Jones. Are you Joshua Jones?
Yes,
Good morning.
Good morning.
This is 25 CR 0031. Mr. Jones was born in 1997.
Yes.
Last 4 digits of social security number 7938.
Yes, Your Honor.
You're here for the purpose of a run counsel. You identify yourself.
Jasmine King.
Okay. The grand jury of Clinton County has indicted you for speeding, trafficking in marijuana, possession of controlled substance in the 1st degree, possession of controlled substance in the 3rd degree, driving too fast for traffic, it's hard for me, reckless driving and trafficking in a controlled substance. You understand those charges? Counselor, you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea or not guilty, reserving all pretrial motions.
Yes, Your Honor.
Be back here on the 13th for negotiation and on the 18th for your pretrial. Okay, both of them conditions are brought.
Thank you, Judge.
I'm gonna take a quick break here. Stop the record. Michael Keith, it says he's in federal custody, is that correct?
I
Mr. Stockton?
says he's out. Yes, he was in federal custody, but he was released in 23. And so we couldn't keep a hold of the Fed. The federal government will not recognize a holder from the state.
Well, why should they? It's
So-
inferior courts that we are.
So, I'm asking for an arrest warrant so we can put him back in CIC.
Yeah, I've tried to reach him, Your Honor, have not been able to, so perhaps we'll. get
Issue
him.
an arrest warrant. Michael Likens. Michael Likens. Commonwealth versus Michael Likens, 24 CR 0074, 24 CR 008.
Right, that infirmary over there, my office now, there.
Well,
Are you Michael Likens? Are you Michael?
Yes, sir.
Likens? You were born in 1960,
Yes, sir.
last four digits, social security number 3813.
Yes, sir.
I've been informed that you wish to enter a plea today, is that correct?
yes.
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yeah.
Are you the same person named in indictments number 24 CR 0074 and 24 CR 008?
Yeah.
Is your judgment impaired today in any way? Is your judgment impaired today? You know what's going on here?
Yes.
Is your judgment impaired though?
No.
Okay. Have you discussed this matter with your attorney and you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? Do you believe you've been fully informed about your case?
Yes.
Okay, you understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yeah.
I'm gonna go over them to the end of them. I'll ask if you know them, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to a speedy trial by jury. Your right to be represented by counsel at your jury trial. Your right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charge against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes.
And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law in the event that I do not accept the recommendation and decide to impose a harsher sentence. You have the right to withdraw your guilty plea. You understand that?
Yeah.
Now, I'm going to ask you a couple of qualifying questions. Have you previously been diverted in the last 5 years?
No.
Pre-trial diversion.
No.
Have you had any felonies in the past 10 years?
No.
Are you presently on probation?
No.
Okay. And you understand if you successfully complete the pretrial diversion, the charges will be dismissed and you can have your record expunged. Do you understand that?
Yes.
However, if you do not successfully complete the diversion, you're brought back in front of me and I find out and I void your diversion, we will schedule a hearing for you and you'd be a convicted felon. That can be used against you in the future for other felonies. Do you understand that?
Yes.
Okay, you move to your left a little bit, sir. Miss Gordon Anderson.
Yes,
What
Your
is the
Honor.
Commonwealth's recommendation?
Upon a plea of guilty to receiving stolen property, a firearm, the defendant shall receive a sentence of 3 years, pre-trial diverted for 3 years, supervised. The defendant shall forfeit the 22 caliber permitted pistol to the Commonwealth and be disposed of in accordance with the laws of the Commonwealth and the holding agency. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum 30 hours of community service per week until gainful employment is obtained.
Is it, okay, come back over here. Is that your understanding of the Commonwealth's recommendation? Is that your understanding?
Yes.
Okay, are you pleading guilty because you did do the act charged in the amendment in that?
This is an Alfred.
You what?
This is an Alfred.
I don't take out.
Well, that's the trial.
Okay, that's it. If a person is not willing to accept or acknowledge what they did, then I don't have any use for it.
Your Honor, the
Okay,
Commonwealth and I,
let's get a date.
the Commonwealth and I have discussed this at length.
Okay, well, we'll discuss it more when you have a trial here.
We'll have time.
Okay. And Tuesday a bad day anyway. How about June the 25th?
It's good for me, Your Honor.
Yeah, that's fine.
Okay, thank you. James McIntosh.
All right, good morning.
Dale Morris. Are you Dale Morris?
Yes, Your Honor.
Were you born in 1982?
Yeah.
What are the last four digits of your social security number?
2944.
Okay, you're here today in 25 CR 00019. What does the Commonwealth have to say?
Pre-trial diversion.
A motion been tendered says that you wish to enter a plea of guilty today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yeah.
Are you the same person named in the indictment number 25 CR 00019?
Yes, sir.
Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes, Your Honor.
Have you viewed the evidence the Commonwealth has against you?
Mhm.
You believe you're fully informed about the case. You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know you understand those rights. And I'm going to go down through the rights, and at the end, I'm going to ask you if you understand. You have a right not to testify against yourself. No one can make the same thing. Right to speak to the jury. Right to represent the counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to high court if you lose. And the right to require the Commonwealth to prove you on a reasonable doubt your guilty charge against you. Understand that by entering a guilty plea today, you give up those charges. You have the right to it. And we consider the Commonwealth's recommendation by the range of sentence by the law. In the event that I do not accept the diversion, you have the right to withdraw your plea. Okay, have you had any diversions in the last 5 years?
No.
Have you had any felonies in the last 10 years? Are you currently on probation?
Mhm.
You understand if you fully complete the diversion agreement, the charge will be dismissed pre-trial diverted. However, if you do not successfully complete the diversion, you'll be brought back in front of me, and if I find that you violated the diversion program, I can void it. And then schedule a sentencing, you'll be a convicted felon. That can be used against you in the future. You understand that?
Yes, Your Honor.
You step to your left a little bit. Mr. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to flagrant non-support, the defendant shall receive a sentence of 3 years, pre-trial diverted for 5 years, supervised. The defendant shall pay monthly child support payments in the amount of $273.76 plus a monthly arrearage payment in the amount of $100 for a total monthly payment of $373.76. The regular child support payment of $273.76 shall be due on June 15th of 2025, with all subsequent payments in the amount of $373.76 being due on July 15th, 2025, and due on the same day of each month thereafter. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained.
Know what you agreed to, sir? Are you entering this plea because you committed the acts charged in the indictment as amended?
Yes.
Doing so of your own free will. Knowing your constitutional rights, still your desire to enter this plea and allow the court to fix punishment within the range permitted by law. Is that true? Is that your signature on the docket?
Yes.
I'll accept the agreement, sign the diversion order. You need to meet with the probation and parole officer there just to give us some information first. Dylan Murphy. Dylan Murphy. Says active warrant on Dylan Murphy.
Yes, yes, he is started from drug court. That's what it means, he asked him.
Jimmy Poyer. Commonwealth versus Jimmy Pointer, 25 CR 0008. Are you Jimmy Pointer?
Yes, sir.
Born in 1986.
Yes, sir.
Last four digits, social security number 8306. Is that
It
right?
is.
You're here today for sentencing. Have you had an opportunity to review the precinct, the 4-year probation parole?
Yes.
Okay, is it substantially correct?
Yes.
No changes? No. Or plead guilty to wanton endangerment, first degree, 4 counts, defendant shall receive 5 years on each count to run concurrently for a total of 5 years, probated for 5 years. He shall enter and complete the Clinton County Special Court. The defendant shall pay restitution in the amount of $850 at a rate of $100 per month, beginning 30 days from the entry of a plea. Subsequent payments every 30 days. Restitution shall be dispersed in accordance with the restitution order. Restitution subject to 5%. Who knows the court costs? $155, so I add another $25 a month. You can pay toward your court costs starting 30 days from today, okay? You need to meet with the probation.
Sir, that, you can go ahead and speak.
He has a question about the time he's been credited on his PSR. I said I would mention.
Now, apart from that, he just read that the plea agreement was a 5 for 5, 5 years probated, and it's a 4 for 4.
It's a 4 for 4, that is
With
true.
specialty court, and I've already made my $100 payment for the month.
Well, let's go back and look at the agreement.
And there's 98 days jail credit.
Well, we'll get to that in a minute. Mr. Stockton, is this 4 for 4 or 5 for 5?
It was 4 for 4.
We'll make that, we'll amend the judgment accordingly. And then as far as your jail credit is concerned, probation and parole will take a look at that. And if you're in any disagreement with what they find, you can bring it back to me, okay?
Okay.
Yeah. Thank you. Yeah. Seth Roberts. Says active warrant.
Yeah, real quick, please, guys.
Okay. Brandy Scott. Brandy Scott. Information, it's a rocket information. I don't have a copy of the information. Mr. Stockton.
Copy of information back, please. Yeah, he's got.
It's information, the information.
Here you go.
Squad. We had one of Matt Hughes for Friday come in, skipping. Y'all, Brandy, Cheyenne, Scott.
Yes, sir.
Just come to order, y'all key in the mic. Ms. Scott, you're here by virtue of information. What's your year of birth?
94,
And what are your 4 digits of social security number?
1200.
By information that come with the charges you, with, defense possession of controlled substance, first degree methamphetamine, you know those charges.
Sir.
Mr. Bailey. Counselor, you acknowledge that giving your client receiving that in a way form or reading or any plea of not guilty resulting on pre-trial motion.
Yes, Your Honor.
Hey, is this a diversion?
It is.
As you've heard, I've just been informed that you filed a motion that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drug or alcohol?
No.
Is this plea freely and voluntarily given? Are you the same person named in this information here?
Yes.
What are the last 4 digits of your social security?
1200.
Is your judgment impaired today in any way?
No.
We discuss this case with your attorney.
Yes.
Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
Do you believe that you've been fully informed about the case?
Yes.
I understand that you do not have to enter a guilty plea today. You have certain rights on the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. Now I'm going to go down through the rights. You have a right not to testify against yourself. No one can make you say anything, right to speak, trial by jury, right to be represented by counsel at your jury trial. You have the right to complain, cross-examine all witnesses, call to testify against you, right to produce evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove on the reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea today, you give up those charges.
Yes, sir.
I may consider the Commonwealth's recommendation that if I, but I may apply a range of sentence without the law, I might refuse to do a diversion. If I do that, you don't have to accept that. You can withdraw your plea and go to trial. Do you understand that?
Yes, sir.
I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years? Have you had a pretrial diversion in the last 5
No.
years? Have you had any felony convictions in the last 10 years?
No.
Are you currently on probation? Are you on probation?
She is on probation in district court.
Is Commonwealth aware of that?
I am, Your Honor. I don't think it affects.
It won't. I'm just making sure you're aware of it. Yeah. You're correct. It does not affect it, but could. You understand if you complete the diversion program, the charges will be dismissed, pre-trial diversion, and you haven't expunged. Do you understand that? If you don't complete the diversion program, you're brought back in front of me and I find that you violate, I void your pre-trial diversion. Schedule a hearing and sentence you to a convicted felon, and that can be used against you in the future. Do you understand that?
Yes, sir.
Mr. Stockton, will you come forward with your Commonwealth's recommendation?
Yes, Your Honor. She'll plead guilty to possession of controlled substance, first degree, 2-year sentence, pretrial diverted for 4 years, supervised. She'll be referred to the SSC, follow all recommendations, obtain gainful employment or do a minimum 30 hours community service per week, and all evidence in this case will be destroyed.
Okay, is that what you agreed to?
Yes.
Are you pleading guilty because you did commit the acts charged and amended the indictment?
Yes.
Then so your own free will. Knowing your constitutional rights to explain is still your desire to give up those rights, and you're guilty plea to allow the court to fix your punishment under the conditions that are explained. Is that your signature on the motion?
Yes.
I accept the agreement. I will sign the diversion order and you'll need to make the probation program. What's the fine and court costs? $155. You need some time to pay that? Let's pay it $30 a month. First pay the $25. 25 days a year, okay? Nathan Stockton. Nathan Stockton. Is it Stacy Stockton or these companion cases?
Well, there's the two cases done for pretrial conference are companion cases. This arraignment is just Mr. Stockton individual.
Cromwell versus Nathan Stockton, 25 CR 0022 and 25 CR 0036. Are you Nathan Stockton? I am. You born in 1991?
Yes, sir.
Last four digits, social security number 5920.
Yes, sir.
Represented by Mr. Poindexter. You're here for arraignment on one of the charges, and that would be in 0036. You have a right to remain silent. Grand jury of Clinton County's attorney indictment charging you with theft by deception. You understand that?
Yes, sir.
Mr. Solomon, acknowledge the identity of your client received indictment away formal legal and remedy your plea not guilty, reserving all pre-trial motions.
I do, Your Honor.
Negotiation date is on June 13th. The next court appearance is June 18th, both of them at 9 a.m., both of them conditions your bond, okay?
Your Honor, I've asked that the two pretrial conferences be passed at the same negotiation and court date.
Okay, on both cases.
Mr. Stockton and Ms.
On
Stockton.
both cases here and then on hers. Okay, I call Commonwealth versus Stacy Stock. The 13th and the 18th. Commonwealth versus Stacy Stock. 25 CR 0021. Are you Stacy Stockton?
Yes.
You born in 1993. Last four digits of your social security number 0103.
Yes.
You have the right to remain silent, represented by Mr. Soam. It has Stephen Poindexter on here. Were you involved in this?
No, Your Honor.
Just-
At arraignment, it was indicated that there was an entire unit in case of the arraignment.
Okay. Okay. Okay, well, I guess you'll schedule your negotiation day on June 13th and the next court appearance on June 18th. Mr. Stockton, what's the nature of this charge?
The one set for pretrial conference involved contract between the Wayne County Fire Department and the procurement of the signs, about $26,000 to claim the work never performed. And then the other one is $7,500 per tablets claiming that he delivered a utility pole that is stopping to put a sign up and advertising.
Okay, see y'all then.
Thank
Same
you.
conditions your bond.
That's all right.
Wesley Stockton. Commonwealth versus Wesley Stockton, 24 CR 0086. Are you Wesley Stockton? Born 1984. Last four digits social security number 4085.
Yes.
Pre-trial conference was Commonwealth.
Mr. Rutherford furnished me some information last night and I need to go over with the sheriff, so we can have one more jurisdiction there.
9 a.m. on June the 13th is your negotiation date. Your next court date's on the 18th. 5 days later, both of them conditions your bond. You understand it? You may go. Thank you. Joshua Talent. Commonwealth versus Joshua Talent, 25 CR 0028. Are you Joshua Talent?
Yes, sir.
Born in 1989.
Yes, sir.
Last four digits social security number 3393.
Yes, sir.
What does the Commonwealth have in this case?
Oh, you always ask the Commonwealth. Your Honor, we filed a motion for Mr. Talent on behalf of him regarding the stop and the reported consensual search. Spoke with Mr. Stockton. It'll take a little while to do. I think we've agreed to be heard at the court's convenience, but not today.
Just set it for next month, I won't get hurt, I think.
Yeah, and if we don't resolve it that way, we probably.
We can set a date between now and then.
Be
Get
fine.
your calendars read. What is the charge, Mr. Stein?
Possession of controlled substance, first degree. For the latter, the total, he had about 170 grams of methamphetamine. So, we'll have no witness.
Is a witness a state trooper or?
No, yeah,
Um, can we hear it come with him?
We don't care, that's fine, we'll make ourselves available.
Let's do it on 22nd. May,
That'd be in the morning, or
we'll do the afternoon. We'll do the doc. I was just saying. 2:00.
it'll be fine.
Great.
Before we got to-
2:00, let's say. Hey, if you talk to me, right here. Hey, come, you get a hold of it. Great. Next, I don't figure. And we just have all the rangers. We wouldn't make rangers.
Richard Thompson. My one versus Richard Thompson. Are you Richard Thompson?
Yes, sir.
Good morning. This is 25 CR 0029, Commonwealth of versus Richard Thompson. Mr. Thompson, you were born in 1976.
Yes, sir.
Last 4 digits of social security number 1479.
Yes, sir.
What's the Commonwealth have to say here?
Thank you, Mr. Poindexter. We had just a little bit of discovery. We want
Yes,
one
sir.
more break out.
Yes, sir.
Negotiation day on June the 13th at 9 a.m. The next court date is June the 18th at 9 a.m. Both of them conditions are okay.
Judge, that's all I have, can I be excused?
Absolutely.
Thanks, sir.
Leanna Traylor. Leanna Traylor.
No objection.
No objection. William York.
That's a felony.
Commonwealth versus William York. 25 CR 00030. Are you William York?
Yes.
Good morning. Okay, all right. Let's hold it down to a slight roar, okay? Were you born in 1984?
Yes.
Last 4 digits, social security number 0755.
Yes.
We're here on a pretrial conference. I understand that you wish to enter a plea today. Is that right?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this freely and voluntarily given? Is it freely and voluntarily
Yes.
given? Okay, are you the same person in that number 25 CR 003?
Yes.
Is your judgment impaired today?
No.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence which Commonwealth has against you and you believe you're fully informed about your case?
Yes.
You understand that you do not have to enter guilty plea, you have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. Ultimately, I'm going to ask you. You're right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to use evidence, right to call witnesses in favor, right to appeal this matter to higher court if you lose, right to appeal this, right to apply the Commonwealth pleading unreasonable without each of the elements of the charge against you. Understand? And when you're guilty plea today, you give up those rights. You understand that? And we consider the Commonwealth's recommendation, but I may apply any range of sentences provided by law. Prior to making that determination, however, I will wait a pre-sentence investigation report done at probation parole, and again, I do not accept the Commonwealth's recommendation and decide to impose a harsher punishment. The other way to do I report. You understand that?
Yes.
Mr. Stockton, what is the Commonwealth's recommendation?
Mr. York, will guilty flagrant non-support, receive a sentence of 5 years, probation for 5 years. He'll pay a monthly support payment of $422 with a arrears payment of $206.26 for a total of $620.26.
That'll begin, 422 will begin May 15th. The full amount will begin June the 15th with 600, I'm sorry, and the $620 beginning August the 15th, that total with the arrear. I'm giving him some time to get caught up here. In the event the monthly child support is reduced, the monthly payment should be correspond with the adjusted reduction amount. He'll receive credit for time served and obtain gainful employment.
Is that what you agreed to, sir?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes.
Doing so your own free will?
Yes.
Nor your constitutional rights are explained to you, still your desire to give up those rights. You're pleading guilty and allow the court to fix your punishment.
Yes.
What's the court cost me? $155, and I'll give you some time, $30 a month in addition to required payments, starting probation today. If you understand that by entering this plea, you are a convicted felon, and any future convictions could be enhanced under the range of penalties of law. More, you understand that? Set your signature on the docket.
Yes.
I'll accept the agreement order, precincts investigation report done the probation and parole. Come back on June the 18th for sentencing, okay? Probation, parole. I know we had one case, if you want to go back and go over this stuff with your person.
I've already gone over it with him. He signed all those.
Bring him back around. What's his name?
Joshua Shaw.
Commonwealth versus Joshua Shaw. $25 CR 0004, you are Joshua Shaw. It's a Cumberland County case, Cumberland County case. We previously convened special session here by agreement in Clinton County. Your last four digits, social security number 3558, and you were born in 1993, is that correct?
Yes, sir.
Okay. Motion been tendered says you wish to enter plea today, is that correct?
Yes,
Are
sir.
you currently under the influence of drugs or alcohol?
No, sir.
Is plea freely and voluntarily given?
Yes, sir.
The person previously identified in the indictment. Number 25 CR 004 Cumberland Circuit Court, is that correct?
Yes, sir.
Is your judgment impaired today in any way? Have you discussed these matters with your attorney?
Yes,
Are
sir.
you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you? You feel like you're fully informed about your case?
Mm-hmm.
You have certain rights and you can take the United States Constitution before I accept the plea. I need to know that you understand those rights. We'll go on to the end. I'll ask you. Your right not to testify against yourself, no one can make you say anything, your right to speak, and the jury, right to be represented with counsel at your jury trial, the right to confront and cause to him and all witness call testify against you, right to be evidence, right to call witnesses in favor. Right to appeal this matter, higher court to lose, your right to apply the Commonwealth, with no reason without the guilty charge. Don't you understand that by any of this guilt, you give up all those rights, you understand that?
Yes, sir.
Yeah, we consider the Commonwealth's recommendation, but I may apply. I need to send it to the law if I need, if I reject. Yes. If I reject the recommendation, prior to accepting the recommendation, I will waive 3 cents investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsh sentence, you have the right to withdraw your plea. Understand that? Instead of you going to it. What's the Commonwealth's recommendation?
Your Honor, Mr. Shaw will plead guilty to burglary second degree, receive a sentence of 7 years. He would also plead guilty to fraudulent use of a credit card for the Class A misdemeanor and receive a sentence of 12 months. Those would be concurrent for a total of 7 years. The Commonwealth would oppose probation and shock probation in this case.
Is that what you agree to, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You understand by pleading guilty, you become a convicted felon, and any felonies you have in the future can be enhanced. It's what the penalties. You understand that?
Yes, sir.
Know your constitutional rights, explain to us 2 years out of proceeding, allow the guilty plea, allow the court to fix your punishment. Say that. I told you any future convictions could be made. I already told you that. It's your signature on the docket.
Yes, sir.
You agree with the agreement. Like accept the agreement order precincts investigation report schedule hearing for June 18th. Huh? Excuse me, it's wrong. That's fine. 22nd May. May 22nd May. Thank you. Okay, does that conclude the criminal docket here? Well, I mean, but it's for until we go to Russell County.
What shows up with the courthouse, you want to take him over?
Yeah, pretty much. Commonwealth versus Matthew Crutchfield, 25 CR 0033. Why are you late, Mr. Crutchfield?
My car broke down, sir.
You what?
Beach bottom, my car broke down.
Okay. You born in 1997.
Yes, sure.
Last 4 digits, social security number is 0195.
Yes, sure.
You had an attorney? Yeah. Public advocate, I'll continue. The grand jury of Clinton County turned it out and charged you with public intoxication, possession of controlled substance, methamphetamine, and possession of marijuana. Do you understand those charges?
Yes, sure.
Counselor, you acknowledge the identity of the client received not in way formal reading or any interview not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. We'll schedule a negotiation date on June the 13th, and pretrial on the 18th. And we'll sign a reciprocal discovery order that requires the Commonwealth to provide you information to prepare your defense. You have to be there on both those days and meet with your attorney before then, so you get to be ready for negotiation, okay?
Yes, sure.
Okay, we're going on a 5 you recall more. We're going on a 2-minute recess. Oh, it's already 10 o'clock. I didn't see it on there.
I'm gonna make a request, the IRS be turned up a little bit. I don't think we're being good stewards of Clinton County's money, or whoever's paying the utility bills in here.
Let's go to the Russell County Jail.
Yeah.
Let's go to Russell County Jail. Now, we're back on the record. Tara Ayers, Russell County, Tara Ayers.
Here she is, Judge.
Okay, let's come to order back there, please.
Okay, cool.
Are you Tara Ayers?
Yes, sir.
21 CR 0058. Were you born in 1991?
Yes, sir.
Last 4 digits, social security number 3013.
Yes, sir.
What's the Commonwealth have to say?
It's a possession of controlled substance first degree. Since 23, when she's been placed on supervision, she's had 7 positive drug tests or admissions. She failed out of IOP and refused to go to treatment. I talked to Mr. Garner. He says that she wants to go to drug court. If she still does, that's all right with me. Otherwise, I'd ask she stand and vote.
And we'll stipulate, and she does want to go to drug court. She also asked.
Tara, I've been informed here that you want to go to drug court, and you know that's a pretty stringent program. Are you willing to go and try to help yourself?
Yes, sir.
And she also asked that she be placed on house arrest until she's voted into drug court,
No, I'm
just
not
because
gonna, I'm not gonna do that. We'll get her assessed and into drug court as quickly as possible.
Thank you.
Thank you. Christopher Caraway.
Yeah, she's good.
Are you Christopher Caraway?
Yes, sir.
24 CR 00093. You're here today for the purpose of sentencing. You had a little opportunity to look at the pre-sentence investigation report and the application role.
Yes.
Is substantially correct?
Yes.
Counselor, is any reason not to?
No, Your Honor.
Clark pleaded guilty to trafficking controlled substance first degree, first offense, meth, and sentence of 10 years. The key shall be released at trial. Subject to payment be reasonable storage. Court costs in this situation shall be waived because of length of sentence. Okay,
Thank you, Your Honor.
thank you very much. Ashley Duval. Commonwealth versus Ashley Duval.
Actually, want to pick it up.
Pick it up.
No, you don't have to. I'm in here.
Commonwealth versus Ashley Duval, 24 CR 0048. Are you Ashley Duval?
Yes,
Born in 1987.
yes,
Last four digits of your social security number 45.
yes.
Did you hear on her pre-trial and she was a Commonwealth officer?
Your Honor, she's got, I believe, a 5-year sentence. She was placed in drug court. And she was terminated from drug court on 9/20/24. She's positive for Suboxone and alcohol. 1/25 positive for Suboxone. 4/3/25 positive for meth. 4/7 judge placed her in custody. And if you're not familiar, we meet in the back room downstairs in the basement. Miss McCusker was told to wait outside where the jury sits, and she left. And so she was listed as absconding from the drug court program.
And we'll stipulate to that, Your Honor.
Okay. I'll revoke the version, schedule order of precincts investigation report, schedule the sentencing on June the 18th. Thank you very much. James Guffey is next.
Good morning, Your Honor.
Oh, Commonwealth versus James Guffey, 25 CR 0032. Mr. Guffey, were you born in 1971?
Yes, the year the gold standard changed.
The last four digits of your social security, 18
Yes, sir.
for the purpose of arraignment. You have an attorney?
My attorney was Corey Rutherford.
Okay, public advocate, I'll continue that appointment. You have a right to remain silent. The grand jury of Clinton County charge you with terrorism in the second degree, disorderly conduct, and resisting arrest. You understand those charges?
Yes, sir. I had a mental breakdown that day. I was having a.
No, you don't say anything.
Okay.
Used against you. The right to remain silent. I'm signing a reciprocal discovery order. Your attorney will be over to see you. You have a negotiation date on June the 13th, court date on the 18th, okay? He'll be over to see you.
What is my bond?
How much is his bond?
It's a $20,000 shirt.
It's a pretrial approved surety bond, 20,000. Anybody?
Signature?
No, it's a surety bond. Somebody's got to come into the clerk's office and prove to the clerk that they're worth $20,000 and they can sign your bond. Get you out, okay?
Okay.
Thank you.
Thank you.
Brandon Hall, Commonwealth versus Brandon Hall. Are you Brandon Hall?
Yes, sir.
Morning. This is 25 CR 0039. You're here for arraignment. Mr. Hall, were you born in 1982?
Yes, sir.
Last four digits of your social security number? What?
3773.
I'm here for arraignment. You say you do not have the money to hire an attorney, is that correct?
Yes, sir.
Yeah, I'll point to the public advocate. You may look back later. Thank you. Partial payment for that. You have a right to remain silent. The grand jury of Clinton County's return indictment charging you traffic and controlled substance in the first degree and being a persistent felony. Also possession of controlled substance, first degree, second offense. You understand those charges?
Yes, sir.
Counsel, you acknowledge the interview client received indictment, wait formal email, and interview not go ahead.
Yes, Your Honor.
I'm saying reciprocal discovery order so that parties will provide information. Maybe help you prepare for your defense. You want to negotiate, set up for June 13th, the next court date, 18th, both of them are conditioned to your law. Thank you very much. Christina Sampson. Christina Sampson.
Yes, sir.
Christina Sampson.
Yes, sir.
Here on 25 CR 0042. Were you born in 1999?
1969.
Last four digits, your social security number, 8714.
Yes, sir.
Previously representative of the public advocate's office in this case here.
What did he say about that?
Will the
I'm
public,
sorry.
the public defender previously represent you in this case?
No, I haven't had cancel yet. I requested cancel yesterday.
That's why I'm asking. So I've looked at your affidavit. I'm gonna go ahead and appoint you a public advocate. He's here today. Just gonna do what you got to pay. The grand jury, has returned it. You have right to remain silent. Grand jury, Clinton County returned the indictment charging you with 3 counts. Trafficking, number 1, trafficking in controlled substance. Trafficking in controlled substance, first degree, 3 counts, 4 total counts. You understand that?
Yes, sir.
Knowledge the identity of client received indictment, what formal you and interpret not guilty, voting all pre-trial motions.
Yes, Your Honor.
Your attorney will be able to see and will, and if after he talks to you, you review the bond, contact the Commonwealth attorney and
Okay, thank you.
you are scheduled for negotiation date on June. This pre-trial is on 18th. Okay,
Will I know something about the bond before then?
your attorney is gonna come over and talk to you about your bond. He doesn't,
Okay.
he doesn't know anything about your case.
Okay.
Once he talks to you, if he thinks that you need to accept bond reduction, you can call a comment.
Okay.
I don't know anything about your case.
Okay, and thank you.
Thank you very much.
I'll see you soon.
Russell County, do we have anything else over there today? Is that finishes with you?
That's us. Thank you.
Thank you all for your cooperation. Be excused. Okay, Clinton County. Turn your camera on. Clinton County.
Hold on, Your Honor. I get to come up here.
All right.
Host has asked you to start your video.
It's not.
Unable to access camera. Please allow Zoom Workplace to access your camera from device settings.
Okay. Need Raven to help you with it?
We don't really know much about
Let me
this.
go.
You got to allow access to the Zoom video.
Let's go off the record here until they get on camera.
Just in camera. Hey, found your wallet, boy. I'll find it.
That's what you do.
If it kicks off again, go back into the settings, go to your apps, and you'll scroll down to see soon.
Click on it, allow the access.
Yeah, you'll go to permissions, and that's where you'll re-access everything. So you should be good to go. Okay.
Has that got good signal in there? Probably not. Maybe it was wrong with it in there. It probably got good signal.
Okay, congratulations. Commonwealth versus Michael Ash. Michael Ash. For Raymond. Michael Ash, are you Michael Ash?
Yes, Your Honor.
You born in 1960? You born in 1960?
Yes, sir, Your Honor.
The last four digits of your social security number are 0684.
Yes, sir.
And you're here with the purpose of arraignment in 25 CR 0037. I will continue the appointment of public advocate to represent you. He's here on camera. Grand jury, Clinton County's returning indictment, charging with possession of controlled substance, plus agreement and possession of drug paraphernalia. You understand those charges?
Yes, sir.
Acknowledge the danger your client received indictment away from or in the arraignment of the indictment, which are all pre-trial motions.
Yes, Your Honor.
You have a negotiation date set up for June 13th and your next court date is June 19th. Okay, what's his bond?
It's a $15,000.
You just have a $15,000 surety bond. Anybody can come in and prove to the clerk they're worth $15,000 and they can get you out, okay?
Is there any way I could sign myself out, Your Honor?
No, you have to have somebody sign you.
Do they have to be from Albany?
Do what?
Do they have to be from Albany?
Anywhere in Kentucky. Yeah, people in Kentucky. Okay.
Okay. Thank you, Your Honor.
I'll see you soon.
Jason Craig. Jason Craig.
Yes, sir.
Yes.
Commonwealth versus Jason Craig, 25 CR 0020. Are you Jason Craig?
Yes, sir.
Born in 1978.
Yes, sir.
It's 4 digits, social security number 7123. You're
Yes,
here
sir.
for a pretrial conference, was a Commonwealth have
Have a felony plea, Your Honor.
A motion has been tendered, says you wish to enter a plea today, is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol.
No, sir.
Is this plea free and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 00020?
Yes, sir.
Was your judgment impaired today in any way?
No, sir.
When you discuss this matter with your attorney, are you satisfied with his advice?
Yes, sir.
The evidence the Commonwealth has against you, believe you're fully informed about your case.
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna go over them, then I'm gonna ask you to acknowledge that. You have a right not to testify against yourself. No one can make you say anything. You have a right to spend copy to you, right to be represented by counsel at your trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. And right to appeal this matter to higher court if you lose. You have the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
When we consider the Commonwealth's recommendation, I may apply any range of sentence provided below. I don't have to accept a recommendation. Prior to accepting any recommendation, I will order a pre-sentence investigation done by probation parole. In the event that I do not accept the Commonwealth's recommendation after reviewing such report and decide to impose harsher sentence on you, you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes,
Mr.
sir.
Stockton, will you come forward and tell us what the Commonwealth's?
Your Honor, Mr. Craig will plead guilty to 2 counts of possession of controlled substance first degree. He'll receive a sentence of 3 years on each count to run concurrently for a total of 3 years. He'll enter and complete be probated for 3 years. I'm sorry. He'll enter and complete the Clinton County Specialty Court Program. He shall receive credit for the time in custody and be released upon final sentencing. All evidence in this case will be destroyed.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Are you doing so of your own free will?
Yes, sir.
For the constitutional rights explained to us, you desire to enter this plea without the court to fix your punishment within the range permitted by law. You understand that? You understand that after entering this guilty plea today, any future convictions for felonies could be enhanced. Persistent felony criminal law. Do you understand that?
Yes, sir.
Have the agreement here.
I do.
I'm gonna hold the document up to you and ask you if this is your signature on the document. That's your signature on the document there. You see it?
Yes, sir, it is.
I will accept the plea order pre-sentence investigation report. Running and sentencing will be on June the 18th.
Thank you, Your Honor.
Hey, Jason,
Yes.
Mayor Christie will be down to the jail to give you a PSI packet to fill out.
Okay.
All right, thanks, sir.
Versus David Harden.
No.
Commonwealth versus David Harding. 19 CR 0026. Are you David Harding?
Yes, I am.
You were born in 1979.
Yes,
Last 4 digits of social security number 8938.
yes.
You're here today on a probation revocation in 19 CR 0026. What does the Commonwealth have to say?
Your Honor, Mr. Harding has a 5-year sentence on flagrant non-support. He has unpaid restitution on that of $2,414.25. Evidently, he's been paying over the years, but he owes a little bit more than when he started, when he was indicted in 2019. But the problem is he's got a new felony arrest on wanton endangerment first, discharge of a firearm. And I'll also with the court, I've not got the case yet from the officer, so I would have to, if we have to have a hearing, I'd have to do it next month.
I mean, I would like to wait until the new case is resolved before we handle the revocation.
Well, let's at least, we're gonna put this off until you provide the information through discovery.
Yeah, I'll need to
For
get the case, it's gonna be indicted next month.
Mr. Harding, these new charges are gonna be brought against you. I don't think it's fair to have a probation revocation here until your attorney has an opportunity to talk with you about this and review the case. So I'm gonna put it off. I am gonna put a negotiation date on there in case you get something before then. The 13th. 18th, is that right?
The
June
13th.
13th at 9 a.m. to 18. Okay.
I'll see you
Thanks very
soon.
much. Nathaniel Johnson. Your sentencing. Pamela versus Nathaniel Johnson. Are you Nathaniel Johnson?
Yes, sir.
Were you born in 1986?
Yes, sir.
Last four digits of your social security number are 9661. Is that correct? That's correct. And social security, is that right?
Yes, sir.
You had an opportunity to look at pre-sentence investigation report, you have a probation parole.
Yes, yes,
Substantially correct.
yes.
Your counselor is any reason someone should not be sentenced.
No, Your Honor.
On pleading guilty to burglary, secondary defendants shall receive a sentence of 5 years to serve. On pleading guilty to theft and awful taking, you should receive a sentence of 12 months. 2 sentences will run concurrently, total 5 years.
Yes.
Responsible for court costs and not what? $155, and that'll be paid $30 a month, 30 days after you're released, okay?
Okay.
Okay. Nicholas Kuba.
Hit him earlier, didn't he? When he had a mom.
But I agree.
I don't think. Okay, I'm confused with somebody else. Yeah, I just can't repeat with somebody.
I don't know.
Joshua Jones.
Joshua Jones, okay, that's very.
Cromwell versus Nicholas Kuba, 25 CR 0034. Are you Nicholas Kuba?
Yes, sir.
Were you born in 1988?
Yes, sir.
Last four digits of your social security number are 8824, right?
Yes,
Now,
sir.
do you have an attorney?
No.
Can you afford an attorney?
I'm sorry.
Can you afford an attorney? Why don't you have an attorney? Yeah, I see that you've done the affidavit here. I'll take a look. It looks like you are eligible. I'll appoint a public defender and reserve. See if we make them contribute later to the cost of that. See your attorney on camera now.
Well, Mr. Kuba,
You have a right to remain silent. The grand jury of Clinton County has returned a charge against you with tampering and physical evidence, public intoxication, possession of drug paraphernalia, possession of controlled substance, and you're a persistent felon. You understand those charges?
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client, receiving that and waive formal reading and arraignment and prove not guilty. Reserving all pretrial motions.
yes, Your Honor.
We schedule a negotiation day on June 13th. And then it's on June 18th.
Thank you. I'll see you soon.
Austin Sakura. Austin Sakura.
No.
Are you Austin Sakula?
Yes, sir.
It's 24 CR 0082, Mr. Sakula. You born in 2001.
Yes, sir.
What are the last four digits of your social security number?
8182.
8182. You're on a probation revocation. What is the common that say?
Your Honor, Mr. Sakula has a 2-year sentence on possession of controlled substance first degree. He was a rocket docket case. And he has a new charge of driving, operating a motor vehicle under the influence. He failed several of the field sobriety tests or had a positive indication. He consented to a blood draw and we're waiting on that. So,
Is this a probation revocation?
no, it's a pre-trial verdict.
Okay, well, look, I'll wait to get the results back on.
Okay.
So we'll schedule him for June the 18th. They don't have the blood test results back on you, Mr. Stewart, so we'll bring it back on June the 18th. Okay, thank you. Cody Smith. Cody Smith.
Yes, Your Honor.
Homeland versus Cody Smith, 23 CR 0067. You are Cody Smith,
Yes, Your Honor.
born in 1992.
Yes, sir.
Last week, Social Security number 4167.
Yes, sir.
Commonwealth have about Mr. Cody Smith.
Your Honor, Mr. Smith has a wanton endangerment, 5-year sentence, intimidating a participant in the legal process, 5-year sentence for a total of 10 years. He had a probation violation and was ultimately placed in the specialty court program. And he was terminated from specialty court program on April the 7th. And the main reason was he'd altered a drug test by the fake news. So we're asking for revocation.
Stipulated.
Stipulate, so. Is this a pretrial diversion or probation?
It's probation here.
I will vote the probation.
No, I'm sorry, it's a diversion.
It's a pretrial diversion. I'll avoid the pretrial diversion and order pre-sentence investigation report and schedule your sentencing on June 18th. Okay, now is there anybody else down at the jail we hadn't called that's supposed to be on the docket? If not,
I have the case of Conwell versus Felicia Davis. And I'm asking that the court enter an order of dismissal on that case. That is a case that I only had evidence from one witness claiming that this lady stole a handgun. And the case is based entirely on his credibility, and right now the Commonwealth cannot go forward based on his testimony.
going to dismiss it without prejudice. Dismiss it without prejudice, order be submitted. Okay, that concludes the criminal docket. We're at recess until 1 o'clock. Oh, we have a show cause. Okay. We'll be back at 1 o'clock. Thank you very much. Oh. We're on the record now. We'll call it child support docket, Connor versus Connor.
In this case, Mr. Connor this is an arrearage only case, asking that, he pay 500 by 6/17/25, Judge.
500 by when?
6/17/25.
It's the day before the next rule day. You know, the next rule day is on the 18th.
The 18th, I was needing to. Hell home.
You electronically submit the order.
Yes.
Heiser versus Heiser.
They are here, Judge.
I hadn't come around.
Okay, let me take care of it. Judge, this was a motion to amend, and the child support has done new figures on it, and might be put Stephanie under oath.
You raise your right hand, you swear the testimony not to be the truth, the whole truth, nothing but the truth.
I do.
State your name.
Stephanie Witham,
By whom are you employed?
Clinton County Child Support,
What is your position?
caseworker.
Are you familiar with the case, Amy Fuller versus Emmanuel Heiser?
Yes,
Okay, and what's your involvement in that case?
I'm the caseworker.
Okay, and were you asked to review this case?
Yes,
Okay, and who asked you to do that?
the petitioner,
Okay, and who is the petitioner?
Amy Fuller.
Okay, and what was the original child support amount?
$325 a month.
Okay, and what was the basis for the review?
Increase in wages.
Okay, and where does Mr. Heiser work?
D&D Enterprises.
Okay, and were you able to ascertain his income?
Yes,
Okay, and were you able to run it through the Kentucky child support computer that we have?
yes, according to the guidelines, it would be increased to $603 per month.
Okay, and how many children are there?
One,
One. Okay, and I know you just answered my question, but is this based upon child support guidelines?
yes.
Okay. So,
Would you like to ask any question?
Is there any way I can get documentation relationship?
Yes.
yes,
Spending the,
Will you come back? He's got a right to ask you questions.
Okay.
Hey, where did you get the information about his wages?
His employer,
I mean, directly from the employer, offline?
directly from the employer. We don't count overtime. So it's 40-hour work week or less.
Yeah. I knew there was, well, one of the reasons I'm actually, there's this computer. Somebody told me y'all had computer access to income information.
That will often contain overtime. So we like to get it directly from the employer.
That way you don't use overtime.
Right.
That seems like a pretty dramatic increase.
It's more than double, yes.
Okay, would you give him an opportunity to look
Yes.
at that? You got the worksheet
I
ready?
think you got it in the mail.
I guess my question was, is there any way that I can get documentation on what you do from child support?
No.
Or,
You know, once the child support goes, once they get the child support, they can use it. Of course, obviously, you can't raise a child for $600 a month. You can't provide for a child for $600 a month. You know, I don't know what other kind of benefits or things that she gets, or whether she works or whatever, but once the child support is there, unfortunately. Now, is there any split custody of this thing, or timeshare or anything?
Not that I'm aware
How
of.
many children are involved?
Just one.
Okay, how old is the child?
14.
13. So, you know, many times the presumption now is for 50-50 as far as, that's not the presumption now.
You will not see her.
I didn't ask you to say anything. I'm just saying what the presumption is. I'm explaining to him what it is. I'm not saying, I wasn't stating how it is, okay? But so you didn't understand. It's okay. It's all right. So, but, you know, the only way that could be reduced is if in the past you had a custody order where you saw the child a certain amount of time or that sort of thing. That time is gone. If the child is 13, that's probably not gonna happen. So, that calculation, now, I'll let you, you got a copy of that, so I'm gonna have to enter an order based on that calculation. So is there anything else? Does that include, now what about insurance? Child got, K-chip? It's K-chip, okay. Well, $600 up from $325, but you're not asking for any go back and that starts now. So you don't owe any arrears. Okay, well, thank y'all very much. Yeah. Okay, Bird versus Bird.
There's an agreed order in that case, Judge.
Smith versus Smith. Smith versus Smith.
Judge, in this case, place here on that, the non-custodial parents are ordered to pay $200 a month and 50 on arrears, and the arrears right now is 3,400. So we're asking 500 be paid on or before June 17th.
Okay, Smith to order. Orton versus Orton.
Have an agreed order that's been submitted, Judge.
Okay. Cabinet versus Farrell.
Ricky is here, Judge.
Okay, tell me about this.
Judge, in this case, there's two children involved, and the last payment was on 2/3 of 25 for $86.31.
What's your name, man?
Ricky Pearl.
And the arrears right now is $3,033.13. Was asking 1,000 by 617.
Who's to pay that? Her?
Me, yeah.
Can you do that?
I'm in drug court at the moment. I just had a baby. I just now faced up in drug court. And the reason why I haven't paid anymore is because I haven't been working. Like I got laid off from Tyson because I was septic where I had the baby. So I mean, if I have to, I could probably do it, but I don't think I can. Like I'll be able to pay the full thing at the moment.
What?
I can probably do like 600 by then.
Well, let's do something. Who has the child?
My sister has both boys.
Well, let's do 500 on regular payments plus 500 on arrears, and then 30 days after that, another 500. Does that make it easier on you?
Yeah.
Okay, that seems reasonable. That way you get the 1,000 within so many days, but she's got these other obligations. So, okay?
Okay, thank you.
Thank you. Yeah. Buster versus Tucker. Buster versus Tucker.
I think they're here, Judge. This is Kathy's case. I think she'll have to testify a little bit, Judge.
Great. Tell me what this is about.
This is a default judgment motion to set child support.
Okay.
Yes,
It's right. Testimony about here's the truth, the whole truth, nothing but the truth.
I do.
State your name.
Kathy Parson,
By whom are you employed?
Clinton County Child Support,
And what's your position?
caseworker.
Are you familiar with the case we're hearing today involving Dana Buster versus Naomi Tucker?
Yes,
Was a complaint filed against Miss Tucker?
yes,
Okay, and has she been served with that?
yes, March the 3rd.
Okay, of this year?
Yes,
Okay, and as of today, this motion, had any response been, received any answer or response?
no, I had talked to her a few months ago, but she never did come by.
And, so how many children are involved in this case?
6.
6,
Mhm.
okay.
6.
And where are those children located?
With her sister was Dana.
Okay, this is Dana. Okay, so, was the child support figure amount come up with in this case?
Yes, it's under the state guidelines,
Okay, how
Yes.
much was that?
at $327 per month.
Is it based on minimum wage?
Yes,
That's my next question.
Yes.
Is that based on minimum
Yes.
wage? Okay. Yeah. When were those payments set to begin?
May the 1st this month.
Okay, do you have any questions you want to ask?
No, sir. I have no problem telling it. Like when they call and tell me they need something,
I get it, we're not paying anyway.
This is, this is the way you need to do it from
Right.
here on out.
I mean, I'll do this
And,
plus
and,
that.
and you understand that from here on out, that's what you can depend upon, 327.
Oh, she doesn't ask me for anything.
Well,
I'm talking about when the kids do.
I know, but she can help with the kids to understand that it's important for the children to know, even though you're raising the children and have the children now, that their mother is providing some basic things. So if they want to ask for things, they need to go to that 327 first. You know what I'm saying? See what I'm saying?
I do.
Yeah, I want you to get credit for paying this, is what I'm saying. Okay, thank you very much. Okay, Stearns versus Stearns.
Judge, we're gonna renotice Matt Garman and Ms. Hawley's involved in that. It's private counsel and they may come to some type of resolution.
Does that finish that docket?
It does.
Okay, thank you very much.
Thanks, Judge.
Okay, let's start the civil docket. Okay, the civil docket starts at 1:30. So let's go off record for a second. Let's go through all this. Papinal versus Fested.
Probably an agreed order of substitution of counsel in
Why
that
don't you come
case.
up here? Yeah, I noticed there was a motion to substitute. Was there another motion to be heard that?
Judge, new counsel has entered an appearance and we have, I'm here on behalf of Yasmin, have agreed to pass that motion. His motion to revive and file an amended complaint based upon the death of the
Yeah.
defendant.
So the substitution counsel is the only thing there.
Yes, and that's been tendered, I believe.
Yeah. The other one, who was the attorney that filed representing the state?
Travis Bell is now.
Yeah, that's what I
entering the
saw,
case.
yeah.
So he'll be handling this.
And he had not had a chance to look it over and ask us to pass it.
Okay, that's good.
Thank you.
Okay, thank you. Mitchell versus Mitchell.
Judge, I was notified by the attorneys that they're going to continue to generally as the new counsel's being retained.
Okay, continue generally. That's when Allison Hunley is removing herself from practice, so she withdrew. Kelsey versus Kelsey.
Your Honor, I represent Ms. Kelsey.
I was informed about probation controls and Mr. Kelsey was arrested on a probation violation. Our workers were coming into custody.
He called me and I spoke briefly with him a few days ago. And he indicated that he's paying half of one of the debts and within a certain amount of time he'd have the rest. We don't oppose if we pass it another 60 days to see if he does.
There's not much you can do about it because he's in custody.
Right.
So I'm glad you don't oppose it. So it's, the situation is that he has not met his obligation of a divorce decree. Is that what it was?
That was, yes, Your Honor, there's several debts that he ran up and was responsible for.
But it ain't looking good, just, so
No.
maybe you get out and get back to work. Okay, we'll pass over that. Thank you very much.
Thank you. Thank you. What is that, Megan?
You got 60 buildings?
60 or so?
Let's do it till July 10th will be the next time. Continue to July 10th.
Thank you.
Cummings versus PL Albany LLC. Come on up.
Judge
Mitchell, can they leave that? That's pretty good.
Good afternoon, Your Honor. Bill Barnum for LP Albany. This is my motion.
Okay, go ahead.
Okay. In June of 21, Mrs. Cummings admitted her son to the Clinton County Care and Rehab, also known as LP Albany.
Yeah.
Mr. Carroll filed, we agreed to try to do some discovery, try to get it resolved. We weren't able to resolve it mediation.
This case for the LLC problem.
I wouldn't, that's the argument. I wouldn't agree that there's a problem. I guess that's.
There is a problem. There's an argument about the
An
LLC.
argument,
Maybe
yes,
I didn't phrase it precisely.
Yeah, I don't know.
Okay, now what's the other issue besides the LLC issue? You have some kind of motion.
Actually, I don't have a motion, Judge, but I filed a response that also that the power of attorney did not specifically grant.
That's the other issue.
That's the other issue.
I'm not buying into the LLC thing right now. I think that all these organizations have LLCs and things like that. So I'm not buying into that right now. But I am kind of interested in the power of attorney argument a little bit. And I also am interested in whether, it wasn't brought up in a motion, but are we to the state in our lives where nursing homes have an adhesion contract situation that they won't let your person come into the nursing home unless you waive all your jural rights? Is that where we are? Is that what the law is?
Your Honor, I believe there is case law that says that it can be a mandatory part of the admission process. And courts have allowed that to be a mandatory part.
So somebody that's an attorney, in fact, can deny someone their juror rights when it's not specifically set out. I know we have had this back and forth over whether attorneys in fact can give things, and that's where I guess we got that in another case today, maybe, or something like, maybe, but I looked at this stuff and kind of looked at the case law. Do you think there is any case law in Kentucky about attorneys in fact doing away with the juror rights for the person who they hold?
I think there is, Your Honor. I think that the Kindred v. Clark opinion that we both cited went to the U.S. Supreme Court, and the Supreme Court said there doesn't have to be a specific granting of a power that says a bright line, it's required to grant, to waive the rights within that power of attorney. As long as the power of attorney grants some pretty broad and general powers to.
They can dispose of everything that you have. There's no doubt about that. Probably under that power of attorney, they can dispose. What do you have to say, Mr. Carroll?
Judge, in addition.
Do you have
to
any case law on that issue?
Well, I think we cited the same case, but you interpret the power of attorney in the same manner you would any other contract. And this was not a general power of attorney. This was a power of attorney that granted specific rights. And
it wasn't a medical.
And it was not.
It was broader than a medical.
It was broader than the medical, but it did not grant them the right to waive the right to.
Well, what he's saying, and I see the validity of it, that if you have a right to complete as attorney, in fact, completely dispose of everyone's assets, they don't have to have that much specificity to say that you do their juror rights. And he's saying that the case that he has, and I didn't read it that way. I must have. I'm not too impressed by.
But it has to be a general power of attorney.
Yeah.
And this was not a general power of attorney.
Well, of course, you can determine, it doesn't have to be entitled as a general power of attorney to be a general power of attorney, does it? If it actually gives the rights to everything. I'm not so sure. How does a federal litigation on this point affect me? Is it because there's some kind of federal connection that's now,
Well, it was a U.S. Supreme Court.
There are a lot of U.S. Supreme Court cases that don't apply to state issues.
Correct. But this was a Kentucky case that went up to the U.S. Supreme Court.
Well, I understand that, but I wonder if they decide on some kind of federal issue, there's bound to have been some kind of.
Probably, Your Honor, decided under the Federal Arbitration Act.
Yeah, that's what I thought.
Right, which is very similar to the Kentucky Uniform Arbitration Act.
And it's similar, but that's the reason that I wonder about whether they found it under the Federal Act. What is the acronym for that?
KUAA and
yeah,
FAA.
Whatever it is. I knew it at one time. I wonder if they found something under the Federal Act is not applicable, whether that also applies to the State Act. Because I'm kind of a person that believes that all issues that aren't granted to the federal government reserved to the state sort of guy. Having turned down a couple of federal judgeships, I'm glad that I did, because I like it here. But so it interests me. I'll just say it interests me. Now, has there been any mediation in this thing? You're asking for arbitration, right?
We tried mediation, Judge, and we're not able to reach an agreement on.
Were you far off pretty far? I'm not going to ask you to give me any details, but you don't think it would help to go back. Now, so you're saying that they're entitled to do this for arbitration, correct?
That is correct.
Arbitration, correct. Now, have you done arbitration on anything like this?
I have, well, not on anything like this. Our office has had one arbitration case, I think, in 50 years of practicing law.
Well, then I don't understand why any nursing home in Kentucky would ever admit anybody that refused to sign one of those things.
I think they won't.
They won't. So and that concerns me somewhat. And that, I guess adhesion contract is not the correct word for it, but pretty close, similar enough. I just don't like that. Now, it might be the law, but I don't like that too much.
I understand, Your Honor.
And that's not that. As Mr. Carroll will tell you, that I'm not all in my career, my previous career, I've not always been the favorite of the people that used to call themselves trial lawyers. Now they're justice people. I wasn't always their favorite. I mean, felt like a kind of a middle of the road sort of thing. It's kind of, I think juries take care of a lot of things now in Kentucky. We don't have a lot of runaway juries like we did at one time. But I'll read what you have to say. You feel pretty strongly about this LLC thing that you got?
I do, Your Honor. And
Give me
to better explain
help me out
that,
with that a little bit.
this contract was with basically a DBA.
Yeah, that's right.
Or that's who they wanted to be, was with the LP Albany LLC DBA Clinton County Rehab.
Yeah.
But in fact, it was with a non-existent limited liability company, Clinton County Rehab and LLC. So there is no LLC. For example, if I had sued Clinton County Rehab and LLC,
Well,
my case would have been
let's
dismissed.
let's go back to the ownership. This had to do, the nursing home sold at one time, correct?
The nursing home's owned by Albany
The building or the business?
I'm assuming both.
You
but I don't
can't
know
assume
that.
that sometimes because.
At least the business is owned by LP Albany LLC, whom we sued. The contract is with Clinton County Care and Rehab LLC, which doesn't exist. Had I sued according to this contract.
So there's a misnomer situation, you think, where on their contract or release that they required arbitration by, they had the wrong entity on it.
They had a non-existent entity.
Well, of course.
Holding itself out as a legal entity.
Yeah, and it never had been a legal entity?
No.
Okay. And what you're saying is that was just a misnomer, that it was actually the same entity? Is that
No, Your
right?
Honor, what I'm saying is that with the Secretary of State, they filed Clinton County Care and Rehabilitation Center as the doing business as named LP Albany LLC. It's filed with the Kentucky Secretary of State as a name for the business.
What do you say to that?
But we did not sign a contract with them. We signed a contract with an LLC that doesn't exist. The difference is the LLC at the end.
So the LLC that was filed at the Secretary of State's office is a different named LLC than you signed a contract with?
Well,
Answer that question.
Okay, their DBA is Clinton County Care and Rehab. Our contract is not with LP doing business as that entity. It's with Clinton County Care and Rehab LLC. So they're holding themselves out as a separate LLC that doesn't exist. Never has existed. And had I sued that LLC, first thing I would have got would have been as soon as the statute of limitations expired, would have been a motion to dismiss because I'd sued the wrong entity.
So the entity that's listed on the contract with the arbitration clause in there does not exist?
Does not exist.
Okay, what do you have to say about that?
I would say that it does exist, Your Honor, but even.
Tell me how it does exist.
Does it register with the Secretary of State as such? But that's
The
what
one
I'm
that's
saying.
the one that's named in the contract.
Right,
yes.
Clinton County Care and Rehabilitation Center is, LP Albany LLC is registered to do business as Clinton County Care and Rehabilitation Center.
And your contract was Clinton County Care and Rehabilitation.
LLC.
I would just say, Your Honor, even if the LLC is not existing or there is an LLC at the end in the arbitration agreement, which I will agree, if you look at the pre-printed form, it does say LLC afterwards. Unless there's some evidence of an intent to defraud somebody by using a wrong company, then the contract still exists. And there's been no evidence of any kind of intent to defraud Mr. Cummings or his mom when she signed the arbitration agreement by having an LLC.
Well, back in
after
my,
it.
I'm not ever as, had the level of practice you guys did, but one of the most distasteful things that ever happened to me is I represented a little feed company over in Burksville. This lady inherited from her husband. She ran the feed company. And some people came in there and every ticket that they signed as an LLC. She didn't know the difference between the LLC. It had some company name as LLC, and they beat her out of the entire fee bill because she didn't have anything signed with them personally. And, you know, I mean, I understand the importance of LLCs and the legislature. We really changed the law down through the years on the LLC and other entities that, or so you could operate from state to state. It bothers me somewhat that what Mr. Carroll has to say about the defense it would put up if he had sued the wrong entity. And he says that you should be bound by the same situation as far as whether your release is from that entity or not. But similarity in just leaving LLC off of it, that's a good argument too. This is a case that should be settled because whatever I decide in this case is going up. There's no doubt about it. There's just too many things that are problems. I'll take it under advisement, although I probably won't ever know any more about it than I do right now. But I'll take a look. So the two issues that we have is the validity of a person as attorney in fact signing situation, and it's whether the correct parties were named in the document that created the arbitration clause. Those are the two issues. Now, is there anything else that I'll look at? And y'all present all the case law on either one of those. I tell you what I want you to do to help me, since I'm not as familiar with this line of work as y'all. I want both of you to do a short brief on both of those issues and do your case law. That way it won't tax my mind as much as it
So supplement our existing briefs. Sean.
Yeah, that'd be just with honing in on those things and, you know, kind of simplify the arguments a little bit for me and then then we'll read the cases after we do that. I don't want to do anything rash on the thing because, as I say, I'm not as familiar with this area of law as I am other things, and we really don't face. But we ought to transfer it to a business court somewhere like they have in Louisville or somewhere up there, where they got those Harvard and Yale graduates, not mere U of L graduates. That's what. Oh, cool. Thank y'all for your good arguments here.
Thank you, Your Honor.
May I be excused?
Absolutely.
I believe that's all I have as well, Judge. Thanks.
There you have a safe. Owens, let's see. What's the next case? Owens and others versus the Medical Center at Clinton. You find this.
Your Honor, I'm here for the defendant in this matter. Plaintiff's counsel and the defendant, we've agreed to pass this motion to June 5th, but I wanted to just make sure that you all received the agreed order.
18th. We've had to reschedule the June 5th because of bar association.
Okay. Yes, Your Honor.
If you'll tell your co-counsel, get us a order down here electronically, we'll file it, continue it to June the 18th, okay?
Okay, yes, Your Honor. We'll refile that order and put June 18th on there. Thank you.
Paula Pickens versus the Medical Center at Clinton.
Your Honor, this is the same issue, same plaintiff's counsel, same defendant. We've also passed that motion and we can file that order for June 18th.
Thank you so much.
Thank you. Have a good one.
Thank you. Steve Byer versus Gary Wallace.
Good afternoon, Judge.
Hello. Good afternoon, Your Honor.
Hello.
It's our motion, Your Honor, to alter, amend, and vacate the court's most recent order in this case. The court will recall this.
Counsel, can you hear what's going on here?
Yes, Your Honor.
Go ahead. Excuse me, Mr.
As the court will recall, Mr. Byer, who was a 49% interest holder in Dale Hall at Charcoal, brought this action against Mr. Wallace and Dale Hall. And the court, in a manner that we viewed as a bit hasty, entered a very substantial judgment for $700 some odd thousand against Mr. Wallace, when actually at the time went beyond what Mr. Wallace would request. We've been holding that in abeyance, and there's been a lot of moving parts in this case, including an involuntary bankruptcy filing in Bowling Green on Dale Hall that was initiated by Mr. Byer. Mr. Byer, I think, probably regrets doing that because it's my understanding that now the purchase contract on the property where this charcoal plant's been located has been set aside, and Mr. Anthony Wilson got the property back. So Mr. Byer is probably not in too good of a financial position before all this came down. Anyway, what the court did last time, it certified this as final and appealable with,
You asked me to do that, but
Mr. Wallingford did.
I thought you asked to.
No, and we've got counterclaims. We've got claims that have not been dealt with. And if this goes to the Court of Appeals, then basically what the court's done, it's dismissed or held our counterclaims for naught without any motion, without anything being addressed. It's just Mr. Wallingford comes up and says, we want this certified as final and appealable. Then we appeal it. Court of Appeals, I believe, will kick it back, and we're going to ask them to. But it's just a quagmire.
Well, it is a quagmire.
Yes.
And quite frankly, my head spins when I try to draw a diagram of it, which
Me and you both.
and you talk about what Mr. Byer regrets taking it down there. I'm sure a lot of things, Mr. McGuire, I'm sure he regrets ever hearing the word charcoal at all.
Yeah.
You know, and maybe the people he invested with, I hate to hear the name Mr. Byer at all.
As the court recalls, we've mediated this thing, seemed like for days on end, and thought we were close to getting it settled and didn't.
Well,
Lo and behold.
here's the thing. Even if my judgment stands, that wouldn't dismiss the possibility of you advancing on your claims that you have.
Well, how do we do that if we've had to appeal it to the Court of Appeals?
Well, you appeal that judgment, which does not include this other portion of the counterclaims at all. I mean, there hadn't been a judgment done on the counterclaims.
And of course, there would be offsets there. I don't believe.
But they can have an independent judgment against the judgment that was entered in this case. Couldn't they have a separate claim?
I have my doubts if the Court of Appeals will want that done until the case runs its course.
Well, then let one of them come down here and try this case, because I don't think this case can be tried. I don't think with all these interrelationships and things that it can be tried without some guidance from the Court of Appeals or someone as to whether or not my judgment is correct on this. Now, this case, it appears it's a 23 case, but it seems like it's been going on much longer than that to me. I mean, I guess it's kind of when someone's twisting your arm, 2 years seems like a long time, but I've anguished over this case, not, trying to unpeel the onion and what was equity investment and what was a loan. And then those are some of the issues that you bring up. Isn't that correct?
Yes.
So I don't know, whoever, I don't want to cause anybody a malpractice problem, but whoever drafted up the agreements in this were pretty loose, and what kind of agreements they were entering into. I don't know.
I think they were simply done the way the fellows directed them. I don't think
That's
you can
what
blame it on
lawyers can't
counsel.
do. Lawyers cannot do what the people that are investors, because you hire lawyers. If you're an entrepreneur, you should never get a lawyer as a partner, because they can only tell you what you can't do. And if you don't listen to them about what you can't do, sometimes it bites you. And if you don't listen to them what you can't do, and sometimes it bites you and you can apologize for doing that and go on, then you're a real entrepreneur and you make money. But in this situation, there's no apology that's going to come. It's kind of like when I used to do those blue sky cases where people had inappropriately gotten investments in all.
Allegedly.
Well, they didn't follow the blue sky laws, and then they had rescissions. And then people say, well, this guy he didn't qualify as a sophisticated investor, and they didn't go through the disclosures and all that sort of stuff. This case here is beyond my capacity to unwind. I don't think it could ever be taken to a jury. I just don't think it could be taken to a jury, because the prejudice that would be involved, the jury, I don't think could comprehend the complex issues that were here and the instructions and that sort of thing. I just don't think it could be done. So it'd be a hometown deal, in my opinion, on who's from here and who isn't from here. And although I value people that are from here, you know, one of the things I always said that after I'd gone to places and that had happened, I think that, I mean, what could you tell me that would make me think y'all could advance this to submit all the arguments and all the things to me and have it fully briefed, all the evidence taken? I mean, I put a receivership in, that didn't do any good. This other company was put in and was marketing the thing, that whatever the other company was that Cowboy was the one who was?
No, it was, the three.
Yeah. Well, I just think there's all sorts of things here that throw up flares to me that there might be self-dealing going on, or the outside investor or the outside person loaning money here. You know,
To me, Your Honor, this was a case where you put everybody in one room and don't let them out until it's settled. But we've done every
you let
doggone
them out,
thing we
Mr.
can
Crosby,
do.
Rob.
Mr. Wallingford may want to be heard, Your Honor.
Mr. Wallington, I've been arguing your case up to this point. So
Well, I appreciate it, Your Honor, and you're doing a great job. This is, I believe it's our 5th or 6th time in court just on this very issue. So I think we've definitely visited and revisited again these issues. The record is very well demonstrated, the facts and the law behind this court's ruling, and supported that ruling as well. This is a motion to alter, vacate, or amend. As we
let me ask you about their counterclaims. What about Mr. Cross's argument that my judgment stands that they will not be able to redress any issues that they have with the counterclaims, whether you think the counterclaims are valid or not? I'm not asking about the validity of the counterclaims. I'm just asking their jural access, if there's not a better word.
Your Honor, the counterclaims themselves have been discussed in the record. We have gone through the facts, and this court ruled on the merits of those counterclaims as well. The counterclaim involves money that was in the possession of Dale Hollow Charcoal. The entire time we showed how it was in the possession of Dale Hollow Charcoal, involved $40,000 in an account that was in the possession of Dale Hollow Charcoal, a QuickBooks account. So that it has been, the counterclaim was raised, and we demonstrated to this court that it's not a set-off.
Well, is that counterclaim addressed in this judgment, you think?
Your Honor, I certainly believe so.
Well,
They're not.
I don't think specifically that the counterclaim, that there's been a summary judgment on the counterclaim.
There's not been.
And that's what Mr. Cross is saying, that although some of the issues might be raised as a defense, or something in this judgment might be raised as a defense in this, to the counterclaims, as such, the counterclaims have not been acted upon. Is that what you're saying, Mr. Cross?
That's correct, Ron.
Yeah. And how many counterclaims? What are the counterclaims that you have?
There's a couple of specific actions we allege that Mr. Byer.
No, I'm not. I'm just talking about break them down to what they are.
I'm sorry that I can't do that precisely, Your Honor.
Okay, I've heard all this I need to hear, except I am issued, Mr. Wallingford, I am concerned about whether or not I have inadvertently included something about, I never intended to do anything that would destroy the counterclaims. Okay. I think the judgment that I have based upon the way this is proceeded, I don't have any question about that really. And I might be wrong, because but I'm not in doubt. I just might be wrong. See, if I'm wrong, the Court of Appeals or Supreme Court will tell me that I'm wrong. And then once they give us instructions on how to go back and do this right, if I'm wrong, then I'll be glad to follow those instructions, But I want you both to address what I have done that might cut off these counterclaims, and if it's possible for a ruling to be final and appealable on a case like this that makes a decision on the complaint but does not address the counterclaims, if they can be separated. And I thought I knew the answer to that, but that really hasn't been directly addressed or briefed, I don't think. Has it, Mr. Wallingford?
Your Honor, I certainly feel that the counterclaims themselves have been addressed in the course. You're indicating that you don't believe so. But
I'm not saying that I don't believe it. I'm just saying that I don't know that they have. And that I didn't see anything in the judgment that I heard that addressed the counterclaims. I think specifically, we stated that when I was here, that I wasn't addressing the counterclaims, that I was addressing the complaint. Now, if the complaint extinguishes in some portion the counterclaims, then you need to make that argument too. And it might very well be that you're true. I don't want you to make it today. I would like for you to make it in writing, Mr. Cross. I'd like you to present something on whether it's impossible. And if I'm convinced that the counterclaims cannot rise and will fall based upon the judgment that I've made on the complaint, then that's what it is. If Mr. Cross can convince me that the counterclaims separately addressed cannot be addressed if I do not overturn the judgment on the complaint, then I need to know that. But right now, I need to know whether the defendants in this case will still have an ability to redress any problems that they have as far as their counterclaims in a separate action, or in this action, if the Court of Appeals, the Supreme Court says that there's something wrong, that my judgment stands. And I don't know the answer. But if, Mr. Wallingford, if you can show me why these counterclaims cannot stand, I suggest that you make a new motion for summary judgment on those counterclaims.
Okay. So I think I would just want to add one thing, Judge, because I'm looking at the counterclaims right now.
Okay.
And they're all claims that Mr. Byer received advances from Dale Hollow Charcoal. Those claims are Dale Hollow Charcoal claims, and Dale Hollow Charcoal is currently in bankruptcy. So to the extent that Dale Hollow Charcoal has any claims in here, they're not Mr. Wallace's claims. They are Dale Hollow Charcoal's claims that have to be dealt with in the course of the bankruptcy case.
Yeah, if that's the case, that solves that issue.
I certainly think so. I mean, I'm looking at the counterclaims right now.
Look at them right now. His system is a little different than yours. You've got a big manila folder.
Yes, we're going to have to go to something different one of these days.
No, you won't. You just retire.
I never
You're
do.
retired
Yeah,
guy.
I'm in the Hal Pritchard mode right now. He recalls it.
You do have an electric typewriter and computer. You can say the old name.
You know, I used to keep things in really great order in files, and it seemed like people got in there and moved stuff around.
Well, I'll tell you what I'm going to do, Mr. Cross.
Thank you, Your Honor.
I'm going to give you 10 days to disprove what Mr. Wallingford said about who has the counter.
Okay.
It's not really fair to you, client, to this new argument that has been presented. So, Mr. Wallingford, I'm going to now this motion give Mr. Cross give Mr. Cross 10 days to prove that the counterclaims are not of the entity that's in bankruptcy. Right? If they are of the entity that's in bankruptcy, then I'll just deny your motion overall and y'all can handle that. The backups.
And if we determine that they are not, then we want to go into.
I'll deal with that then.
Thank you, Ron.
Yeah, I'll deal with that then. I mean, I think Mr. Wallen is convinced that that's not a problem, aren't you, Mr. Wallen?
Correct, Judge.
So I don't think he's gonna go down that hill on what might happen if this or that happen. Okay, well, thank y'all very much for your patience with me.
Thank you, Judge.
Yeah. Claiborne versus Kettler. Okay, Marcus Riddle, correct, and then the respondent is Leslie. That's right. And then
The grandmother and.
yeah, well, let's take this off the record because we have a matter. I think it's appropriate to put that in the chat. So a matter.